or four coming up. Anyway, looks like we're on.
Yeah, already.
Just do a mic check, audio check. Okay. Um, Good afternoon, members of the panel. Before I begin, may I confirm that I'm audible and visible? Okay. Could I confirm who is the presiding arbitrator? I think we need to hear him say something.
It's you, Maartje. You're the presiding arbitrator.
Ah, yeah, okay,
As
fine.
power emanates from the people, which is me.
Wonderful. Just give me a moment. I'll set up my timer.
Sure.
All right. Okay, before I begin, I would like to settle the housekeeping matters. So I'm Ramesh Kanna and I act for the appellant, Mr. Antonio Fortuna, together with my co-counsel, Mr. Brandon Zhang. I'll be speaking on the first two issues for 10 minutes, followed by my co-counsel on the last two issues for 10 minutes, and we respectfully reserve 1 minute for rebuttal for the two of us. Members of the panel, the case that confronts us today requires the panel to take a stance on this sliding scale between procedural fairness and substantive justice. Now, we do acknowledge that in the vast majority of cases, the position to be taken has already been cemented, both in the CAS Code and the FIFA Disciplinary Code. However, there are exceptional circumstances which warrant this balance to be shifted. And today, in the case that confronts us, the heart of the contention is whether this case falls into such an exception. And our position as the appellant is that it does. In this regard, I have two submissions. Firstly, the statement of appeal is admissible by a reinstatement. And secondly, Mr. Fortuna's refusal to hand over his phone was not unlawful. Now, with regard to my first submission, I make it on two grounds. Firstly, the filing was attempted within the deadline. And secondly, reinstatement should be allowed. Now, the deadline for the statement of appeal is concretized in Article 50, subsection 1 of the CAS Code. It is 21 days after receipt of the final decision. Now, the first contention that respondent counsel may come up with is whether the filing was even attempted within the deadline. Opposing counsel may
I'm
contend.
I'm so sorry to interrupt, but can I just get you said Article 50.1?
Yes, subs of the
Um
FIFA statute, Mr. Arbitrator.
oh,
I
the
believe
FIFA
I
statute, right.
have an error.
Right, got it. Sorry, please continue.
Apologies. Yes. So opposing counsel may contend that the final decision was made on the 31st of March, and that thus the deadline ends on the 21st of April. However, the word decision, as per R31 of the CAS Code, is decision with full grounds. That is, the 21-day window period begins on the 2nd of March and ends on the 23rd of April. And this can be confirmed in the 2016 CAS decision of Ivan Balado and PFC. Thus, the filing was indeed attempted within the deadline, that is,
Um
before 23rd.
Sorry, that last case that you mentioned, did it involve FIFA as the respondent, or was it
No,
someone else?
it's
Okay,
someone else, Mr. Arbitrator.
sure, I got it. I'm asking because if you look at the FIFA statutes, Article 50.1, that's the language we got to interpret, right? So my question is, how can the CAS code be used to interpret this word final decisions in the FIFA statutes?
Yes, Mr. Arbitrator, and the reason for that is because although the FIFA disciplinary code, although the FIFA disciplinary code governs whatever proceedings that FIFA proceeds to take on the appellant, the case today is occurring in front of the CAS panel, and thus the definition that is to be required is what the CAS identifies as final decision. Now,
Fair enough. Sorry, could I also just ask, this word lodged with, is it seen from the senders, so counsel's point of view, or from the court's point of view, meaning received? Does lodge with mean sent at or received at?
That is precisely the contention, Mr. Arbitrator. It means to be received, especially for electronic filings. With regard to R31 of the CAS code, electronic filings are admitted only upon receipt by the CAS office. And in the present case, we acknowledge that the electronic filing was not sent within the deadline, and therefore the deadline has been breached. However, the purpose for which I was earlier explaining when the deadline ends is to understand that it was attempted within the deadline. Because had the filing not even been attempted within the deadline, the question of reinstatement no longer exists. Thus, the heart of today's contention is whether reinstatement as a remedy should be provided. Now, reinstatement can be allowed in cases where two conditions are met. Firstly, the failure to meet the deadline must have been due to no fault of the party. And secondly, the request for reinstatement must have been prompt. Now, this was seen in the 2024 CAS decision of FC Football Club SA and Galatasaray AS. It was also seconded in the 2019 CAS decision, PFC and UEFA. Now, we do understand that reinstatement as a decision in itself is debatable within CAS jurisprudence because there are cases that deny this request on the grounds that equal treatment of parties as a principle is being violated. However, even in these cases that opposing counsel may rely on, it is stated that exceptional circumstances do exist. Now,
And on that note, sir, could I just ask you? So, you phrased the rule as saying, and I quote, it wasn't the party's fault. Could I just ask, what do you mean by fault? Do you mean that the reason why it's late is not something attributable to the parties? So, in other words, fault means the party caused it, or not? Does not the party's fault simply require that the party is not at fault in the sense that they hadn't committed negligence, willful default, that sort of thing?
understand the question, Mr. Arbitrator. No fault. That requirement centers on the principle of foresight. That is, whether the incidence of disorder was foreseeable, such that the appellant is at fault for not taking the preventive measures. And at present, in our case, the email failed due to a cyber attack. Now, the most analogous case to this scenario would be the case of Christina, Iowa. This particular case also involved a failed electronic filing via email. However, the failure occurred due to an expired security certificate, which caused the email to not be sent to the CAS office. Now, why this is distinguishable from the present case is because in the precedent case, the issue of the security certificate expiring was one that was foreseeable and could have been fixed and prevented because it expires on a set date. However, at present, the cybersecurity attack was one that was unforeseen, caused by a malicious third party. That is why we would argue that the no-fault requirement has indeed been met. The more contentious element is actually the promptness requirement. And in this case, we do
I'm
note.
sorry, counsel. Could you just go back to that question about no fault? Because is it not also reasonable to say that in this day and age, cyber attacks are rife, and as such, they are foreseeable? Maybe not the particular instance of this cyber attack, but the fact that there might be cyber attacks is certainly foreseeable.
I understand the question, Madam President, and I think the underlying concern there is whether the measures that were taken by appellant's counsel can be considered to have met the due diligence standards. And in this regard, we would note that as per the clarifications under procedural order number 1, this was the first cyber attack and there had been no prior cyber attacks that had affected appellant counsel's firm. Thus, we would say that they have done whatever they could within their reasonable due diligence to meet the standards of the no-fault requirement.
Let me just check. Do you know precisely when the attack occurred? Now, I see there's a WhatsApp message saying that the IT staff told the lawyers of the attack on 26 April. So does that mean that the attack took place on 26, or was it before that?
As per Exhibit 9, the attack had taken place before that. That is, during the submission of the electronic filing, the attack had taken place such that the electronic filing could not reach the CAS office. However, this
Sure.
issue.
Well, I mean, so if I may, the attack was in force or ongoing or had effect at the time, right? Because for all we know, the hacking could have been done way before that, right? Months before that, which then raises the question, can it be said that counsel has done their due diligence if the system that they have in place to tell them about cyber attacks is so slow that it only tells them, I don't know, weeks or months later?
I would like a moment to contemplate the question, Mr. Arbitrator. Could I refer members of the panel to page 62 of the PDF record? Under clarification 6 in Annex 1 of the procedure, under clarification 7, apologies, it stated here that all the cybersecurity measures implemented by the appellant prior to the cyber attack were up to industry standards. And we would rely on this to state that whatever functionalities that their cyber systems had was what was reasonably possible at that point in time. Now, understand that I have 30 seconds before my time elapses. Could I request for 2 extra minutes to sum up my submissions on the second issue? Now, members of the panel, with regard to the second issue, the refusal to hand over the appellant's phone was not unlawful because of Article 6 of the ECHR. Now, why Article 6 of the ECHR is relevant is because this panel sits in Switzerland, and Switzerland is...
Okay, if I may, I think we get roughly, or speaking for example, I get roughly speaking the appeal to a fair hearing. My question is more, in the first place, what is the rule governing FIFA's power, as it were, to call for evidence? Where do I find that rule in the first place?
Article 12, subsection 3 of the FIFA Disciplinary Code states that FIFA is entitled to request any form of evidence from the appellant, Mr. Arbitrator.
And that's all it says, no requirement of, I don't know, reasonably necessary evidence or anything like that?
Exactly. There is no such qualifications with
Okay,
regard
I'm
to
so sorry. Can I just trouble you to tell me that section number again? You said 30, what?
Article 12,
Ah,
subsection 3 of the FIFA Disciplinary Code.
right. So
It's
it
in
says persons shall provide any evidence requested. Right. And so you're saying that this has got to be read subject to the ECHR. Do you also say it should be read subject to anything else?
no,
Is there
our
some other body
argument,
of law of evidence?
CAS jurisprudence would also be necessarily involved. And the Swiss Federal Tribunal's interpretation of Article 6 of the ECHR is also relevant because any awards from the CAS panel are subject to annulment by the Swiss Federal Tribunal. Thus, that would be effectively the final court of arbitration. Now, I
Hmm.
note that my time has once again elapsed, Mr. Arbitrator. Could I just request for 30 seconds to sum up submissions?
Yeah,
In
bro.
this regard, why Article 6 is violated is because there are parallel criminal proceedings that are ongoing. And if there's a clear and imminent danger that whatever information is collected within FIFA's trial would be sent over to the public prosecutor of Iridonia, then we could say that it is well within the appellant's rights of Article 6 to refuse to hand over his phone. And here the clear imminent danger threshold is met because there has already been a sharing of information between FIFA and the public prosecutor in that they had sent the anonymous email to the public prosecutor, which is why criminal proceedings had even been initiated. With that, I conclude my submissions if I may be of no further assistance.
Good afternoon, Madam President and Mr. Arbitrator. My name is Brandon Zhang, as introduced earlier, and I appear for the appellant. I will make 2 main submissions. First, that the anonymous witness statement and email statement is not admissible, and alternatively, even if admitted, carries little evidential weight. And second, the appellant, my client, Mr. Antonio Fortuna, is not in violation of match fixing under Article 20 of the FIFA's disciplinary code. I'll now turn to the first submission. We submit that the anonymous evidence is inadmissible for 3 reasons. First, CAS jurisprudence applies strict conditions with respect to anonymous evidence. Second, these conditions have not been met. And lastly, even if admitted, carries little to none evidential weight. When the findings are based on anonymous witnesses, the right to be heard, which is guaranteed by Article 6 of the ECHR and Article 29, paragraph 2 of the Swiss Confederation Constitution, is affected. And the underlying principle is the equal treatment of both parties and to strike a balance between the procedural rights of the party opposing the anonymous evidence, and on the other hand, the necessity to protect the life and personal safety of the witnesses on the other hand. There are 4 strict conditions that must be met. In the 2019 Court of Sport, hereby referred to as CAS, decision of Karim Karamuddin versus FIFA at paragraph 129, the panel held the use of protected witnesses is subject to the strict 4 following conditions: necessity, risk, identity verification, and cross-examination. The respondent relies heavily on 2 cases, the 2019 CAS decision of Karamuddin versus FIFA and the 2009 CAS decision of FK Pobeda. However, in the Karamuddin versus FIFA case at paragraphs 133 to 135, the witnesses were victims of abuse, harassment, and threats. However, despite this, the panel granted the appellant the opportunity to directly cross-examine them by phone with a voice scrambler, and also a CAS counsel was physically present to verify their identities. And in the 2009 CAS decision, Pobeda versus UEFA at paragraph 14 to 16, the witnesses were also exposed to threats, insults, and intimidation, yet the appellants were able to directly cross-examine them, and as well a counsel of CAS was present to verify their identities. If I may now direct the panel's attention to Exhibit 2 on PDF page 33 of the record at paragraph 5. Here, the witness states, I quote, "My identity cannot be revealed ever."
Well, that's not entirely true, because I recall reading somewhere in the record that someone did some verification to find out at least that this guy was a player, right?
Yes, Mr. Arbitrator, we agree. And this was reflected in the clarification as well as the records, but it is FIFA here who has verified the parties. But we argue that the FIFA has a legal interest in this party. And as noted by CAS, under sports jurisprudence, the CAS panel in the 2 cases I had referred to strictly requires that the court itself verify the IDs, and then also the court itself also asks questions in relation to their witness statements.
So
And
let's say we're with you on all this. So I would get that all these are reasons to cast doubt on the usefulness, the weight to be given to these statements. But why would you go so far as to say that the statements have got to be rendered totally inadmissible, meaning incapable of being of any evidential use?
yes, Mr. Arbitrator, and we agree. We don't pitch our case to say it's inadmissible completely. However, we submit that the evidence is substantial. Exhibit 2 is witness statements that are double hearsay. And in the Exhibit 2 at paragraph 6, if the panel's direction may turn with me there, here there are rumors that the father's involved in a criminal organization. And so this is double hearsay. We have a witness who refused to come before the courts, who claims that there are rumors and therefore refuses ID. And presently, in our case, there's no threats, no contact, no intimidation. There's not even a single threat. And therefore, we submit that this falls short of the concrete danger that's been required under sports jurisprudence. If there are no further questions, I will turn to submission 2. The respondent alleges my client of match fixing under Article 20 of FIFA's disciplinary code. We submit my client is not guilty of match fixing for 3 reasons. First, the evidence has not met the threshold of comfortable satisfaction. Second, the Genius betting report itself does not constitute match fixing. And third, the evidence does not provide a connecting link to prove the required guilt under match manipulation. The CAS panel has consistently rejected inference, probability, and suspicion as substitutes for proof of personal participation. The betting data in Exhibit 1, which the respondents relies heavily on, does not in itself show any intent or pinpoint my client, Mr. Antonio Fortuna.
Perhaps could you give us an example of what kind of evidence would be good enough to convict, so to speak, someone of match fixing? I say that noting that, I mean, well, one element of match fixing is giving a bribe, which is inherently difficult to prove because people who give bribes tend to disguise it. And the other is following through by throwing the match, which is again inherently hard to prove because um, how do we tell the difference between deliberately throwing the match versus simply not being great at playing the game or feeling sick or whatever it is?
Thank you, Mr. Arbitrator. If I may have just a few seconds to confer with my co-counsel. Mr. Arbitrator, in relation to your first point, the panel has noted there has to be a connecting factor, and the Genius report itself doesn't connect the player to match fixing. And the panel, in regards to the query about the appellant being sick, now according to clarification record,
Okay, so to clarify, I'm not asking about whether he's sick or not, but my point is simply what kind of evidence would suffice to prove match fixing, right? So first, you need to show that the player played in a way that's, if I may, dodgy out of the ordinary, right? And I suppose the Genius report shows that. Now, it doesn't, of course, it's not conclusive because there's still the question of why he's playing out of the ordinary. The general response is that it could be innocuous reasons, right? He was sick, he's not great at the game, he injured himself, whatever. Which means that some other piece of evidence is necessary to make out the fact that a bribe was given, for instance. What kind of evidence would suffice to show that?
There has to be a connecting factor of repeated contact between a criminal organization or somebody who is involved with the betting fraud and the appellant. So
Okay, can you give a concrete example? So
for
one
example,
example is if you have a video of the guy saying, "Hello, I would like my bribe money now, please, in return for throwing the match." Short of that, right?
yes, and this is what we argue, there is no concrete evidence in our case, but in one of the cases here, in the CAS decision of Alexstrina, in the case of Alexstrina Nedova versus the PTIOS, there was held to be match fixing based on WhatsApp messages, Telegram transfers, betting reports, and performance analysis on those 4 factors. However,
Um, yeah. So I mean, here we have WhatsApp messages, don't we?
the distinguishing factor between that case and this case is that those WhatsApp messages and MoneyGram transfers were linked through the phone. and the messages were linked through her phone, which was investigated. In the two decisions, in the 2021 CAS decision of Ofosu Apaya versus LFF, at paragraph 123, the panel held, based on betting reports, performance analysis, and referee statements, that appellant was not involved. In the 2011 CAS decision, Oleg Pinkovsky versus LFF, at paragraphs 96 to 121, the panel held appellant was not involved and not connected to match manipulation. And the panel in Oleg Pinkovsky held that a player's specific performance did not automatically, cannot be attributed to match manipulation. And if I may, my time is up. If I may just have 1 minute to bring the panel to the records here. If I may ask the panel to turn with me to page 15. At minute 64 here, it says no individual errors were identified. At minute 88, it says Santiago had an injury, apparent hamstring injury, and the inability of Santiago to continue his recovering run led to the goal being scored. And therefore, two of the three goals that were scored was not due to any performance attributed to my clients. And on
But
these,
counsel, if I can interrupt, it would appear that at least the first goal can be attributed to behavior exhibited by your client. And one could also argue that it's that critical first goal that psychologically sets up a team to believe that they may have chances of winning. And there's also that that realization that the markets themselves suspended the betting because they believed that there were inaccuracies in terms of what seemed realistic as far as the chances of the teams were concerned. So is it really so simple as to say there were other goals that might be attributed to the behavior of other players?
thank you, Madam President. If I may just have 30 seconds to address your questions. I have 3 points. First, the goal was stated to be misjudged. And in the 2021 CAS decision, Ofusu Apaya versus LFF at paragraph 109, the panel held poor performance and errors are part of football and cannot establish manipulation, or else there would be claims on every player. And secondly, if Madam President would turn with me to page 16 of the record. On page 16, there are I would like to address at the minute 61. Here, Reyes made a run to meet a cross at the near post, and the forward awkwardly attempted to backheel the ball. The ball ended up rolling out of play. And in the 44 minute here, the Fortuna, at 82 minute here, at the very last line says, though the effort was well saved by Iridonia goalkeeper Fortuna. And so on these facts, it looks like there is also poor performance on the other side, who it may be argued was involved in match fixing. And at the very last minute at 82, my client saves a goal. And lastly, to conclude my submissions, the respondent has not proved intent, has not proved in conspiracy, and there's no connecting factors. Thank you. This concludes my submission.
Madam President and Mr. Arbitrator, can I confirm that we are audible? Thank you. May I begin? Madam President and Mr. Arbitrator, good morning. Good evening. My name is Mark Peter, together with my co-counsel, Mr. Austin Seah, and we appear for the respondent, FIFA. I will address my two issues in 10 minutes. Issue A, whether Mr. Fortuna's appeal is admissible, and issue B, whether his refusal to surrender his phone was lawful. Mr. Austin will then address the remaining issues. Members of the panel, the appeal is inadmissible for three independent reasons, and one of them is fatal. The statement of appeal was not validly filed on the 23rd April. The reinstatement should be refused because the appellant did not act promptly with utmost diligence at once. And even if the statement was rescued, the appeal brief was filed late under R51. The statement of appeal was not validly filed and receipt is constitutive under the CAS code. We accept that the appellant's starting point, the time runs from the receipt of the full grounds. On these facts, the operative deadline for the statement of appeal was 23rd April. But the problem is simple. CAS received the appeal email. CAS never received the appeal email, so there was no filing. If I may take the panel to record 29, page 5 of the PDF.
Well, I don't think the applicant disputes that the thing wasn't filed, or rather, they say that it was filed eventually late. So I mean, I don't think it's in dispute that it wasn't filed by the deadline. The question is simply whether an exception should be made to the deadline. That's the question, right?
Yes, Mr. President. Yes, Mr. Arbitrator. So, Mr. Arbitrator, we would like to contest. I would like to highlight the case of FCB Galsari 2024 CAS case. And in this case, it was specifically mentioned that there are two cumulative points which needs to be met. First, the hindrance must not be party's fault, and second, the party must seek reinstatement promptly once the hindrance ends. And we don't contest the first limb of this cumulative test. We are contesting that we know that the cyber disruption may be outside of the appellant's control. What we are talking about here is that there was no prompt action and there was no utmost diligence done. And using the record, I can show you that the appellant counsel was notified of the cyber incident and that it may have affected the communications on 26th April, which is a Sunday. This can be seen on Exhibit 9, page 52 of the PDF. And the hypo clarifies this was framed as may have. So they still had to act conservatively and make sure there were proper precautions taking place.
I'm sorry, I don't quite understand. Could I just okay, so you said to turn to which page? 52?
Page 52 of the PDF.
Yes. And sorry, what was your point again?
So my point is that the counsel was notified of the cyber incident that the law firm has been hacked, and it may have affected the communication. The keyword over here, Mr. Arbitrator, is the may have. It may have affected the may have affected a disruption. So using the term may have, they still had to be conservative and make sure there were systems or plan B put in place, such as giving a call to the court office. But in this
so when you're saying they did plan B too late, when did they do it?
They asked whether the court office has received the filing 2 days later.
On the 28th of April is
28th of April, which is a Tuesday. And the filing was supposed to be made on a Friday. So Saturday, Sunday, Monday, and then Tuesday. It was only the clarifications were only made on Tuesday. So using this flow of logic, yes.
So, counsel, can you just clarify when, according to you, should the council have reached out to the CAS team, and what exactly should they have asked?
They should have reached out on the day of Monday itself, Madam President, because it is imperative that they need to check whether if the filing in the court office has been made or not. Because if the reason why we say this is because it was supposed to be promptly made, and in this scenario, the counsels of the law firm waited until the day of Tuesday, which was exactly one day later. They could have made a call instead of an email and asked the law firm, asked the CS court office if the filing has been made or not, but they did not do any of that.
But here, just to give you this possibility, if the cyber attack may have impacted outgoing emails, your logic seems to assume that the only relevant email that may have been affected was the email sent to CAS. If this is a law firm sending out many emails, and there's been a recent cyber incident which may have lasted a day, maybe 2 days, it would have meant that all outgoing communication would have been affected.
Yes, Madam President.
So the law firm may have needed more than a single day to address this. Is that not reasonable? Is that still not prompt?
Madam President, it is safe to assume that the law firm is big and they are handling multiple cases at a time. But that does not mean that they should be putting one case in priority and the other case not.
Okay, well, what level of granularity do you want to go at, right? So let's say they told Cass at Monday at 4 p.m. Are you then going to tell us, oh, why did they delay when working hours begin at 9? If we tell them they email Cass at 9:30, are you then going to tell us, oh, why did they delay? It's inexcusable. Half an hour. What were they doing? When does it end?
Mr. President, we are not, Mr. Arbitrator, we are not saying that it was a matter of hours, but it was a matter of a day, a 24 hours difference that could have been done on Monday itself, but it was done on a Tuesday, which clearly shows that they had 24 hours to respond. And
Well, it could have been done on Sunday night. It could have been done at 14:35, a full 3 minutes after the IT guy message. You see what I mean?
Yes, Mr.
What
President.
is so special about where do you get this magic figure of a day from? Is it mentioned in the law somewhere?
No, no, Mr. Arbitrator, but we are trying to imply that the 2 days, it does not constitute the promptness in this scenario. And that is where we are inferring this statement from. Mr. Arbitrator, Madam President and Mr. Arbitrator, understand that I have only 2 minutes left. May I have another extension of 2 minutes to submit my issue B as well?
Yeah, I suppose the question, speaking for myself, is does FIFA really have the trouble to demand any and everything from any person subject to its jurisdiction?
Sorry, Mr. Arbitrator, could you please repeat the question again?
Are you saying that FIFA has the power to demand that any person subject to their jurisdiction hand over anything in their possession, all their phones, all their computers, everything?
Mr. Arbitrator, as we can see in Article 8, as we see in the FIFA clarification, which is page 63 in X1, we see over here that FIFA did not ask for the whole phone, but rather they specifically said they asked for to submit the relevant data of the phone itself. So
I mean, did they ask for? Go on, sorry.
Sorry, but according to the clarification, it says FIFA did not provide a specific list of the data required. So that might still be a fishing expedition where FIFA basically says to the player, hand over all relevant evidence. And then it is for whom exactly to determine what would constitute the relevant evidence.
Madam President, we would like to assert that Mr. Fortuna is a member of the national team, and he does not want to face such an issue where he is in a long and tiring legal battle, and it does put a shame on him and his family's name. So using this flow of logic, we would like to assert that Mr. Fortuna would himself want to get rid of this whole trial as soon as possible and try to contribute and collaborate as much as possible.
Well, I mean, by that logic, why not just invite the investigators into his house to sift through all his papers and stuff? That would be even faster, wouldn't it? If he's really innocent, why not just deliver his laptop by 10-minute courier? Because it's by the next day, I suppose you're going to say that wasn't fast enough or whatever. Where does it end? You're saying that if anyone's accused of anything, they should turn over their entire life to an investigator in an attempt to clear their name?
We understand. I certainly, Mr. Arbitrator, I understand your concern. And may I have a bit of time to calibrate my thoughts? Mr. Arbitrator, I understand your question, and we would still like to submit the argument that FIFA, while they did not provide a specific list, did not really fully ask for the phone itself. We understand that the opposing counsel mentioned that the phone was asked multiple times according to the record, but we are trying to imply that while the phone was asked multiple times, it was only, according to the clarifications, paragraph 14, it was only to submit the relevant data of the investigation.
Okay, well, speaking for myself, and I don't think my colleague, I don't think either of us are nitpicking about the difference between the phone itself, the phone plus the case that protects the phone, a copy of the memory card or the data in the phone. The question is simply, they are making a large demand, right, of a large bunch of information. I mean, we can have it's a separate issue whether they want it in the format that comes on the phone or just a printout or screenshots or whatever. But the fundamental issue is, can you really fault someone for not turning over to FIFA anything and everything that FIFA might, in its sole discretion, call relevant, assuming there's a way to read FIFA's mind, simply because FIFA asks for it? Is there really no limit on what FIFA can ask for?
Mr. President, while there's no specifics in the statutes and the FIFA disciplinary code, which says what is there and what is not there, what is required and what is the limitations of FIFA's request, I can highlight you that FIFA specifically states that at Article 12, the party shall act in good faith throughout the proceedings, which is Article 12, subsection 1.
And then who are the parties? It's not just Fortuna, it's also FIFA, right?
Yes, Mr.
And would you say it's acting in good faith to say, we accuse you of a crime, please give us everything you've got that is possibly related to this crime?
Mr. Arbitrator, I understand my time has elapsed. May I have a few more seconds to answer your question?
Please, please.
Thank you. So the specific code which I just mentioned, Article 12, it also mentions that persons subject to the court shall collaborate to establish the facts and comply with the request for the information. So using these statutes, we are trying to submit that while we were not clear on what substantial amount of information we need, we are trying to say that Mr. Fortuna still should have tried his best to fight the allegations which were set upon him.
That same statute, of course, also implies that FIFA should have tried its best to ensure that he can do that fight in a manner consistent with his right to privacy, etc., right?
Yeah. Yes, Mr. Arbitrator.
And being the one in the position in power, surely, even if you say it's on him for not handing over to FIFA what's asked of him, surely it's also on FIFA to ask specifically, would you please give us this, and this
Correct.
for this purpose, and not give us everything?
Yes, Mr. Arbitrator, I understand. But going back to the clarification itself, FIFA said what is relevant. The key word over here is relevant. And FIFA did not specifically say the whole phone, but said relevance, which means that relevant to the trial itself. So I think this is where FIFA was trying to imply. I completely understand and concede to the fact that FIFA was not specific about the relevant data, but the term relevant is to be taken into consideration over here. And since this was between the athlete and FIFA, the Article 12 of the FDC applies over here. If there are no further questions, I would like to submit my argument and pass my time over to Mr. Austin.
Good afternoon, members of the panel. My name is Austin Seah, as earlier introduced by my co-counsel, Mr. Maxwell Peter, and I'll be addressing the remaining two issues for 10 minutes. Now, turning to the third issue, we submit that anonymous witness statement and email are admissible. Now, the appellant has asserted that there needs to be an actual threat, and in this respect, he cites the 2019 case of Karimuddin. But in that case, it was true that the courts did admit witness statements that didn't demonstrate this actual threat. Rather, a real risk is sufficient. Because in our case, it simply involves an alleged criminal network with ongoing police investigations. If I may turn the panel's attention to page 36, paragraph 2 at Exhibit 5. And at page 32 at paragraph 6, it is noted that a witness describes the appellant's father as an individual with friends in the criminal world. Now, similar to Karimuddin, there was a power...
Counsel, can I just pause you there for a second? What we could say is that the threat here is in a way twice removed. There has been no concrete threat made against the witness, and the source or the potential source of any possible threats that might or might not be made is from an individual who may or may not have friends in a criminal organization. So the immediacy, if you want, of the threat seems to be quite distant.
Certainly, Madam President. In this respect, the court in Karimuddin did acknowledge such a probable difficulty and noted that objective evidence can be used to determine if there's a real risk. In that case, it relied on the fact that a witness was granted asylum due to a possible risk of reprisal, and this was considered to be objective confirmation. Now, turning back to our case, the objective confirmation which can be established is actually the police report itself, the IPP statement itself, because notably, based on the facts itself, they decided to launch an investigation into the appellant's father for these very crimes that he's been alleged of. In this respect, we do submit that this serves as an objective evidence to determine if there's a possibility of a real risk, which is only what is sufficient. And now turning to the second element, we do note that the appellant has also alleged that this witness statement cannot be used in isolation, and we do agree. We are not using this witness statement in isolation to establish a claim against the respondent. Establish a claim against the appellant. However, what we are using it is merely as a corroborative tool. And this was noted in a 2009 decision of F.K. Poveda, where the decisive question is whether the evidence is corroborative rather than decisive. And if I may show how corroboration can be established in our case, if I may turn the panel's attention to PDF page 33 at paragraph 9, it is noted that the witness describes the situation as the appellant himself has told the father to stop pressuring him, and then a couple of minutes later stormed out. Now, this actually ties in with the anomalous betting that could have occurred at this juncture. If I may now turn the panel's attention to page 12 of the PDF, under paragraphs, 6 paragraphs above, under header. Now, it is noted that betting for Comet Land, the opposing team, picked up pace 12 hours before the match. Crucially, the phone call that took place between the appellant's father and the appellant was also the night before, 12 hours before the match began. And therefore, we are using the witness statement as a corroborative tool to determine if there was indeed an indirect or direct relations with the father in relation to the match conspiracy.
Sorry, that sounds potentially big. So can I just get a bit of precision? So first, the suspicious betting started on, 16 October at what time of day? What o'clock?
At page 12, it's just stated that it was 12 hours before kickoff, which is 12 hours before the match began.
Yeah, do you know when kickoff was supposed to be? Is it in the morning or?
It's about 7 a.m.
a.m.?
Yeah.
Right, so the suspicious betting started at 7 p.m. and you're relying on the fact that 7 p.m. is what we would describe as evening or night, and the witness statement just says that this suspicious phone call, if I may, also took place at evening or night.
Yes. So therefore, we are drawing a link between the possibility that the appellant and his father did communicate about the issues regarding match manipulation the night before, which resulted in the increase in betting activity for the opposing team.
That is one possibility, but is it not simply possible that someone would have a conversation about a match the day before the match? Now, it would be quite different if we had any idea what the father was saying, but all we're told is taking the statement at its highest at face value that the father was a source of pressure, and I suppose that he caused anger to his son, the player. Now, pressure could be anything. It could simply be, oh, you're my son, don't let me down, don't let your country down. That's pressure, right? How do you jump to the conclusion this is pressure regarding bribe taking or match fixing or anything like that?
Certainly. In this respect, we'll turn to the doctrine of adverse inference because the appellant himself refuses to hand over his mobile phone. Now, under Article 9, subsection 6 of the International Bar Association rules, an adverse inference can be drawn from the fact if the appellant refuses to give over evidence as requested by the other
Okay, I
party.
got that. So let's say he hands over, let's just say, okay, that he's going to hand over the entire phone. Exactly what on his phone would have been useful to FIFA?
So if I may show a demonstration of such evidence, crucially at the PDF page 34, it shows that the appellant's father has also been possibly using his WhatsApp to show evidence of cryptocurrency transactions. So we will submit that if there's
Sorry, the
any
father
evidence...
has been using whose WhatsApp? The father's been using the son's WhatsApp.
No, the father, in his own capacity, has been communicating with the syndicate with regards to payments regarding the match manipulation itself. So therefore, this shows that the father does communicate evidence of match fixing through WhatsApp. So what we would like the appellant to show is a possibility of a communication on WhatsApp with regards to the text between himself and the father to establish if there's a link. And precisely because he refuses to do it, does allow us to draw an adverse inference that he's possibly hiding something, as earlier noted by Mr. Arbitrator.
But counsel, if I can just interrupt there, I recall seeing somewhere in the PDF that there has been an interview with the appellant where the appellant gave an explanation for the content of that very tense telephone conversation. So the appellant might also reason there is simply no further relevant data because there was a phone call, the content of which I have already disclosed. What more could they possibly want other than private information, which brings us back to a point that my colleague had brought up earlier.
Certainly, Madam President, but if we do take the case that the appellant is indeed guilty of match fixing, what he precisely wants to do is, in his witness statement, dispel any claims or rumors regarding the phone call itself. He wants to disprove any claims of the fact of the nature of the phone call and give evasive answers such as what he stated in the witness statement. Therefore, this will allow him to exculpate himself of any liability. And crucially, there is no corroboration of what the appellant is stating, and it's merely a statement made by himself. Now, I note that my time might be elapsing soon, unless there are any further questions on the third issue.
So just really quickly. So
Certainly.
is there any statement anywhere where he, Mr. Fortuna Jr., the son, the player, describes the contents of the phone call?
Precisely, that's the issue, Mr. Arbitrator.
Wait, so you're saying no, not even a description of
not
the
even a
phone call?
description. So what he could have done is actually provided his mobile phone to give us some light as to what could possibly be going on between himself
Or at
and his
least
father.
provided a statement explaining orally what the phone call was
Yes,
about.
precisely, Mr. President. And yet, sorry,
And
Mr.
okay,
Arbitrator.
and you're saying he would have the opportunity to provide such a statement. So that means that someone told him, hey, we suspect you've been talking about dodgy stuff with your dad, and
Actually,
given him
based on
time to provide that statement.
Certainly, actually, based on the facts itself, as noted by my co-counsel, there was repeated refusal by the appellant to clarify the contents of his mobile phone. And in this respect, we submit that the appellant could have just submitted a statement showing what could have possibly went on to dispel any rumors or an adverse inference. I note that I have about 45 seconds left. If I may have extra 2 minutes for the last issue. Thank you, members of the panel. Now, turning to the last issue, we submit that the appellant had violated Article 20 of the FDC and was liable for match fixing. Now, Mr. Arbitrator had asked an extremely crucial question to the appellant as to what evidence is required. And in the 2009 decision of FK Poveda, the appellant himself had considered that they had relied on betting reports. And also Mr. Arbitrator had rightfully noted that match manipulation is hard to be proven given the inherent concealed nature of it, which was noted in the 2009 decision of FK Poveda as well, as match manipulation was quoted by the court, and I state verbatim, not proven by a smoking gun. Therefore, the position that this panel must take is to analyze the evidence as a whole, taking into account corroboration between different strands of evidence to find if match manipulation can be made out. And
Okay,
now,
sorry to interrupt, but if I could just clarify. So, in the first place, what is match manipulation? Am I right to say that it consists of, in the case of a player, first an actus reus of playing weirdly, if I may, out of the ordinary, and secondly, the mens rea of doing it because you're motivated by a bribe? Would that be accurate-ish?
actually, if I may turn Mr. Arbitrator's attention to Article 20 of the FDC,
Hmm.
the minimal case that the respondent has to establish is if there was an attempted conspiracy that was indirectly linked to the appellant himself. And we submit that based on the facts, this can be made out. Now, turning
Okay,
to
so if I may just state upfront my concern about the Genius report.
yes.
It is a blow-by-blow account showing that at various points in the match, various players, not just Fortuna, but various players from both teams, at various times, both made various mistakes and also did various good things, like sufficiently stopping the goal from being let in or whatever. So do you want to respond to that point?
Certainly, and I do note that this is precisely what the appellant himself has submitted. But we submit that poor performance of other teammates itself actually does not tie in with the pre-match anomalous betting. If I may now direct the panel's attention to PDF page 14, under the conclusion of pre-match betting, it is crucially noted there was unjustifiable betting support even before the match had begun, which in this case means that even before any of those teammates have stepped onto the field. Therefore, we
But
submit that there's...
counsel, how can we causally link this to Fortuna Junior? I think that is still a remaining concern for me. So
Certainly,
I'm willing to accept with you that there have been anomalous betting patterns. So, let's say that we take that as a given. How does that link to Fortuna Junior?
certainly. I do note that my time has once again elapsed. If I may answer Madam President's question. Regards to the indirect nature of this, the 2014 CARES decision of Sevastopol and UEFA noted that benefit of coordination that run through third parties is considered indirect manipulation. Now, if I may turn the panel's attention to PDF page 34, it is noted that the appellant's father had possibly received the $50,000 in dodgy coin. And crucially, the IPP themselves had also investigated Mr. Luck Fortuna's dodgy coin wallet. So therefore, we submit that the appellant's father had received an indirect remuneration that could be tied to the appellant himself. And earlier, I addressed the issue
Why
of...
exactly?
Do we have records saying that the father paid some or all of the money to his
Yes.
son, for example?
Yeah.
Okay, in this respect, we do acknowledge that the threshold that this case must meet is comfortable satisfaction, which is not beyond reasonable doubt. So in this case, we will argue that as long as there's suspicious money flow between the father and the syndicate as alleged here, it does meet the threshold of comfortable satisfaction. And I do note that the panel may have some issues on this, and I will redirect them back to the doctrine of adverse inference, as Mr. Arbitrator had earlier queried if the appellant could have submitted a statement himself. Now, the fact that he didn't provide any clarification shows that an adverse inference may be drawn with regards to the fact that he was indirectly involved in the manipulation of the match. Now, I note that my time has elapsed, unless I may be of further assistance to the panel. This concludes my submissions. Thank you.
Thank you.
Members of the panel, I have 2 points in rebuttal. Firstly, with regard to the admissibility of the statement of appeal, I note that Mr. Arbitrator had questioned the opposing counsel, what level of granularity should the panel take? What is the threshold? And with regard to this, the very case that opposing counsel relies on states that there is no particular threshold that is set in stone, but rather the panel should consider all the circumstances of the appellant counsel in determining whether promptness requirement was met. And in the present case, as Madam President herself had stated, a law firm that operates at this level would have to consider many clients and many cases, and that is why we required the one-day delay to reach out to CAS. And with regard to the second rebuttal, opposing counsel's entire case rests on the causal link between the anomalous betting reports and the anomalous playing with the appellant. Now, we do agree that the overarching evidence might show that there was match manipulation. However, the causal link between match manipulation and the appellant can only be made with an adverse inference. And an adverse inference can only be made with regard to the IBA rules that opposing counsel relies on if there's no satisfactory explanation for the refusal to hand over the phone. And in this case, we have both Article 6, the right against self-incrimination, and Article 8, the right to privacy, protecting appellant's actions. Thus, no adverse inference can be made. I conclude my rebuttals.
May I begin? Thank you. Mr. Arbitrator, Madam President, I understand that my opposing counsel mentioned Article 6 and said that the Article 6 is treated relevant over here. And we would like to assert that even if Article 6 is treated relevant, the CS sets the bar for this threshold very high before any person may refuse cooperation. In the case of 2017 CS case of Jerome Valcat, paragraph 266, we see that the privilege might only extend only where there's a clear and imminent danger that the sporting body is being used to circumvent criminal safeguards, typically requiring meaningful collaborations and information sharing with prosecutors. Here, that is not the case. The Article 6 is treated irrelevant because the bar is too high to meet, and the case which I have mentioned, which is Jerome Valcay, does not meet the satisfactory requirement. I would like to submit my, that would be the end of my server button. Thank you.
Thank you, Profs. We can take a short break if you would like before we go into maybe comments.
Maybe just a couple of minutes if you, well, at least a couple of minutes for me if you don't mind.
Oh, sure thing, sure thing.
If
Yeah.
anyone needs longer, if you need longer.
Sorry, can back here at 4:45 then?
Sure. Yeah.
Okay.
Cheers.
See you. Thank you, Prof.